we say to America is be true to what you said on paper. If I lived in China or even Russia or any totalitarian country, maybe I could understand some of these illegal injunctions. Maybe I could understand the denial of certain basic First Amendment privileges because they haven't committed themselves to that over there. But somewhere I read of the freedom of assembly. Somewhere I read of the freedom of speech. Somewhere I read of the freedom of press. Somewhere I read that the greatness of America is the right to protest far right.
Despite constitutional guarantees, American civil rights and liberties are constantly in danger of violation, whether by individuals, corporations, or government institutions. Regardless of whether personal prejudices or national security concerns lie at the root of these violations, challenging them and holding wrongdoers accountable is imperative for the sake of the constitutional integrity and the preservation of the American way. Trial lawyers advocate for awareness, the truth, and a person's right to know. They believe that in the absence of the truth, all of us stand helpless to defend ourselves, our families, our health, and our way of life. Oftentimes, we don't think about or worry about or understand what is happening to another until it happens to us. Deceits have no boundaries. Disease doesn't recognize the color of our skin or our political party's affiliation. When it comes to cover-ups and false allegations by agencies of the state and the federal government, there is not a soul amongst us who does not have a cringing fear of their overwhelming, awesome power. It is at these times that we need experienced and dedicated trial lawyers, the warriors in the courtroom, who are willing to battle for us tooth and nail in the halls of justice to protect our cherished way of life.
In this insider-exclusive Justice in America Network TV special, our news team visits with Stephen Hanudel of Stephen Hanudel Law in Elyria, Ohio, to go behind the headlines to better understand the extraordinary challenges Stephen and his client, Leroy McIntyre, have faced in their pursuit of justice. In fact, here's Leroy's sister, Yvette McIntyre Allen, to highlight those challenges.
Leroy McIntyre is my brother. That's my only sibling. Me and him grew up together with happiness and laughter under the adverse circumstances which we were facing in our life as little kids. We were brought up as strong individuals. We fight for whatever is not right in our life. We fight, especially when we know we are right. We are superior and inferior people, and we were brought up with strong blood lines of strength in our family. My brother Leroy has been convicted of a crime that he did not commit and has been incarcerated for over 33 years. Justice in my brother's case is freedom. Freedom to be him. Freedom to move about. Freedom to love. Freedom to feel. Freedom to see. Freedom to fight for whatever he believes in. I would like to say that the justice system is not made up like it's supposed to be made up for people. People that are out here struggling and trying to make a living and do wrong and is convicted for a small crime and doing time, extra time for a larger sentence. People need to know that we must all come together to fight. Martin Luther King died so we can have a freedom of speech, a freedom to vote. We need your support in fighting this justice system. The war is terrible on drugs and people that's being wrongfully convicted of crimes. Please come out and help, and please come out and support the next election.
This is the Insider Exclusive, live from Elyria, Ohio.
It is my great pleasure to introduce Steve Hanudel to the show. Welcome to the show, Steve.
Thank you.
Tell our audience a little bit about your law firm. What type of law do you practice here?
I've been in private practice for almost 10 years. Actually, I would say at the 10th year this month that I started my private practice, and I've been by myself. And the independence of it has been very nice. Although you do have to eat what you kill, like any other business. And so I've done a mix of civil, criminal, Social Security, disability, and even within the criminal, there's there's trials, there's appeals. So I've tried criminal jury trials, I've tried civil jury trials, I've litigated appeals in both civil and criminal cases, and then just last month I argued in front of the Ohio Supreme Court for the first time in a murder case.
We are here today to talk about a case that you have been involved with for many years.
Yes.
Tell us a little bit about your client and why we're here.
His name is Leroy McIntyre Jr. He was tried and found guilty of felonious assault and aggravated burglary in August of 1991 in Summit County, which is Akron, Ohio. So, and this all had to do with two incidents on the early morning hours of December 30th, 1990 in Southwest Akron, where two men in ski masks robbed two dope houses at gunpoint, and shots were fired at each location. And then at the first location, a 15-year-old was hit in the calf. Nobody was hit at the second location, but it was well established. It was two men in ski masks, and which none of the witnesses at the second location could identify anybody except for a surprise witness by the prosecutor. But Leroy was the only person ever prosecuted, even though, as what was found out later, that the police were well aware of another person as a suspect.
And what happened?
He was given a consecutive prison sentence. So back at that time, Ohio had a different sentencing scheme. Ohio's sentencing scheme had to do with range sentences. So he ended up getting like 8 to 15 years on the felonious assault. He got 8 to 25 years on the aggravated burglary. And each charge included a gun specification of 3 years each. Right. And so the judge ran them consecutive, everything consecutive to each other.
Usually judges don't do that. They run them concurrently. So you don't spend the rest of your life in jail. Why did the judge do this?
If I'm recalling from the transcript, I don't think the judge, I don't think he specified on the record as to why he was doing that.
Yeah, but it is unusual.
I think it's more common than you think in Ohio, and now the law today requires there to be specific findings by the judge to do consecutive sentences, but I think the appellate courts have been very deferential to the trial judges in that regard.
So he got a maximum of, let's say, 20 and 25.
It was the burglary was 8 to 25 years, so the minimum of 8, and then up to max 25. The felonious assault was a minimum 8, max of 15, and then he had a mandatory 3-year gun specifications in each charge.
So that'd be another 6.
Correct. So in total, it was a 22 to 46 year sentence that he is still serving today.
How long has he been in prison?
Well, he was released on parole in January of 2008, and then that's when he caught another charge, which I question the veracity of that. But he was accused of taking 2 court files out of Akron Municipal Court in December of 2008, which, if, in my own personal opinion, if he did do that, it would have been by pure accident. When I look at the security footage of that incident, it's hard to tell what he's holding, if he's holding files. But nonetheless, he got a 3-year prison sentence for that matter, and that violated his parole on the 1991 case. And so he's been back in prison since early 2009, and they've rejected his parole ever since.
On the grounds of what? That he violated his parole before, basically?
And in Leroy's opinion, I think he feels that the fact that he's fighting his case so hard, tooth and nail, because it's not just what we're fighting in court, is that when he's being mistreated in prison, he says something about it. When he's not been shy to file pro se lawsuits against various government officials, none of which have ever been declared frivolous. I mean, he may have lost, but none of which have ever been declared frivolous. So he's researched the law very, very well and learned the law very, very well in prison, and to a very impressive level.
So what we have here is somebody your client, who was wrongfully convicted,
Yes.
was paroled. Now, usually when you're paroled, you have to admit that you committed the crime. You have to give some sort of admission. How do you get around that?
I don't know exactly what took place in the hearing. I think from what he's told me that there wasn't much of a hearing, that because he had served so much time, because by 2008, the sentencing law changed in 1996. 1996 was a huge change in Ohio sentencing law. So now, how I told you that it's 8 to 15. He got 8 to 15 on the felonious assault and 8 to 25 on the burglary. Today, the max on the felonious assault would be 8 years. He would get anywhere from 2 to 8, and today on the aggravated burglary, he would get anywhere from 3 to 11. So, in relation to today's law, especially by 2008, he had served such a substantial amount of time in relation to what the thinking was now at by then. I think it was more on that grounds that they felt he had served more than enough to justify release.
You're involved with the appeals process for Leroy.
Yes.
What exactly are you appealing?
Well, we're trying to get the conviction overturned.
Yeah.
And one thing I've learned in doing not only working on this case but other wrongful conviction cases is that the law makes it tough for you to challenge and overturn a conviction.
And the reason for that, you think, is what?
Finality. Yeah. It's
done, it's over, and we don't want to tell any of our judges they made a mistake, or prosecutors.
And I'm not even talking the judges yet. I'm just talking with the legislature, how they write the laws in the legislature. The Ohio state law makes it tough because once you've had your direct appeal and you're done, and you lose. I mean, you have your one right of appeal to your local appellate district. There's 12 appellate districts in the state, and then after that, you can appeal to the Ohio Supreme Court, but they don't have to take your case. And which they can only take so many just because of volume. I mean, and so
now you're in the 9th district.
Correct. Summit County is in the 9th district.
So you had an adverse ruling in the 9th district initially on your appeal.
Well, Leroy did back in 1991. Yeah. He lost.
Pro se. He represented himself.
No, he had an attorney represent him back then.
Okay.
So he lost, and then after that, I mean, before I got on the case in 2013 or 14, for all those years, he was challenging himself, or sometimes through an attorney, just various aspects of his case.
So our audience understands this. He tried to appeal his case with another attorney. He lost.
Right.
You enter the picture. You appeal the case again.
As I mentioned before, how the law makes it tough to overturn convictions. And so one thing I've learned is that you have to whatever angle you can find in the case to try to get it reopened, you just go with it. And sometimes you just have to take what the case gives you. And in this case, there were so many things that just looked wrong. I mean, and I'm not talking just the conviction, but I'm talking about just the procedural aspects of the case. And I'll never forget the first time I visited Leroy and met him in prison, and he showed me all the documents. And I'm thinking to myself, like, how can this be? Because I wasn't only a few years out of law school at this point. I'm still sort of wet behind the ears, and you're taught to learn that the court functions in a certain way. It wasn't functioning that way at all. It didn't take much to figure out that there was a total malfunction in this case. And so, for example, the jury verdict form for the aggravated burglary charge, the gun specification did not reference aggravated burglary, referenced another charge, referenced the felonious assault charge. Also, now he was found guilty of 2 charges. He was on trial for 3. And so there was a second felonious assault charge he was on trial for. The jury hung. They could not reach a verdict. Now, when the jury hangs on a charge, that charge is still pending. Either the state has to elect to retry him on the charge or dismiss it.
Mm-hmm. They did neither.
They did neither.
So what's that mean?
Meaning his case wasn't finished. It wasn't finished, and also, too, here's the other layer of complication. So right after his trial, and he showed up for the first day of trial, and his alibi didn't show up on the second day. So he left the courthouse to go search for his alibi witness, and his lawyer did not successfully subpoena the alibi. So, which was his girlfriend at the time, because he maintained he was at her apartment when these incidents happened. So she didn't show up. He goes, looks for her, and then he never showed up the rest of the trial. So he was still free after the verdict came down. He confronted one of the two brothers that he felt did this, and they got into a tussle which Leroy ended up grabbing the razor blade from the guy's hand and cut his throat. And Leroy got indicted for felonious assault, but within the same case. It was not indicted as a separate case number. It was within the same case, and that's critical because this was before the sentencing, and so meaning he still had another pending charge going on.
So what you're saying is because they did not find final resolution with all three charges in the same case, the case is still pending.
In Ohio, and I can only assume it's like this in other states, but there's a term called final appealable order. And a final appealable order, whether it's in a civil case or a criminal case, that is the final judgment entry that closes the case, that finishes the case, that says everything is disposed, it's over, and you got 30 days to appeal. So in a civil case, meaning all claims in the complaint have to be disposed of. In a criminal case, all charges have to be disposed of. If you don't have a full disposal of all charges, and this is law going back to at least 1964 with the Ohio Supreme Court, saying if you don't have a full disposal of each and every criminal charge, the case is not done. There's no final order.
Can the prosecutor do it retroactively? Can they say today, well, we're closing the case, we're not going to prosecute him, then it's the case closed?
They could, but then that would mean you still come out with a final order he had no final order. Okay. So
another final order would still be pending?
Yes, well, if he never had a final order, and that's what the Ohio Supreme Court found. But the Ohio law is very clear that the appellate courts, they have no subject matter jurisdiction over an appeal that does not come from a final appealable order. Okay, so if you don't have a final order, you cannot appeal.
And the appellate court can't hear it.
So for all these years, from 91 all the way through 2016, Leroy had been up to the 9th District 10 times and not once. And you're talking, there's different judges that come and go. So I'm not singling out any particular judge. I'm just talking about the institution. Not once did they ever spot that he didn't have a final appeal.
They missed it. The case should not have been before.
Correct. They should have dismissed the case and said, go get a final appealable order. And they do that a lot today. I've had it done in other cases I've worked on where they said, sorry, that order's not final. We have to dismiss the appeal for lack of jurisdiction, go back and get a new order.
So you took this to the Ohio State Supreme Court.
And what we did there, because when we realized, okay, wait, we don't have a final order here, because there's no one document that disposes of all the charges. You still got the pending felonious assault charge that the jury hung on, and there were just other loose matters too. So we're thinking to ourselves, well, we have to, if you don't have a final appealable order, you're not allowed to appeal. So that then means you have to go to an extraordinary writ. And so there's under Old English law, you have writ of mandamus, prohibition, procedendo, and that's where, under writ of mandamus, that's where you sue a government official to compel them to execute their official government duties.
And that's what you did.
So we sued the Summit County Common Pleas Court, the trial court, and the judge on his case at the time in 2015, sued them in the Ohio Supreme Court. And that's one of the rare instances where you can initiate an original action in the top court, because most of the time you can't do that. But this is one of those rare instances where you can do that. So we filed a direct lawsuit in the Ohio Supreme Court against the Summit County trial court and the judge to compel the judge to issue a final appealable order. And we waited for about 11 months. So we filed in January 15, and then finally 2 days before Christmas of 2015, and when I was thinking, okay, we're not going to know something till after the holidays, but lo and behold, they came out with a decision and we won. Now it was a plurality decision. It was like there's 7 justices in the Ohio Supreme Court. One, the Chief Justice, who used to be the Summit County prosecutor, had recused herself. So we were down to 6. So it ended up being 4-2 in Leroy's favor, but there was a split in the majority. So it was
to get another to get an initial
Right.
final resolution.
That mandamus, so the mandamus ruling was ordering the judge who was then currently on his case in 2015 to issue a final appealable order. Yeah. So now the Summit County Court was under the Ohio Supreme Court order to issue a final appealable order. And they specifically made a finding there's no final appealable order. And also, there's a concept called res judicata. And that means it's been decided. And res judicata goes in with the concept of finality, where once you've had your chance to argue your case,
can't get another one.
And you can't get another bite at the apple. And there's an understandable logic to that, because you don't want people to try to clog the system with just coming back again and again when they've already had their chance. It's understandable.
So when the court is ordered to give a final resolution to this, what happens?
The Ohio Supreme Court specifically found that there was no res judicata in Leroy's case, which means all issues are on the table.
He can appeal it again.
Right. So the judge issued a final appealable order on February 3rd of 2016.
Dropping that last felonious assault.
Yes. And now there's some other technical issues that we've taken issues with, but for purpose of what we're doing today, the felonious assault charge was resolved, and you had a single document that resolved all the charges. Yeah. So we appealed. Which meaning, because if that's
appealing on a wrongful conviction now,
right? So if that's the first final appealable order issued in the case, that means all the prior appeals are void.
Right. Goes up to the 9th district.
Goes up to the 9th district.
Same district.
Correct.
What do they do?
We appealed in February 16, and there was some wrangling over the record for about a year. We eventually we filed briefs in 17. I argued the case in August of 17. And then in May of 18 is when they issued a decision. They said, we're applying res judicata to your issues. You already had your chance to argue your issues back in 1991, and we're not going to hear your issues on the merits. They totally refused to address the issues on the merits.
What do you do now?
Well, we filed a reconsideration, and
en banc, in front of the whole bench.
That, and also there was just a reconsideration in front of the 3-judge panel. At that point, I was not happy with the decision, because I felt very strongly that if any of those issues were ruled on the merits, and there were 2 issues, sentencing issues, okay, that the prosecutor conceded. Yeah. The prosecutor admitted, yes, that sentence has to be vacated, which means, under today's law, under this current sentencing scheme, his max is 25 years. He's already done that time. So if he would, even in the worst case scenario, if they would uphold the verdicts and not overturn that, at the very bare minimum, he'd go back for resentencing. Under the prosecutor's concession, go back for resentencing, he'd get sentenced under today's law, it'd be time served, and he'd walk out a free man.
So where are you today?
He's still in prison. And so the 9th District just earlier this month, 11 days ago, denied the reconsiderations. And I attempted to disqualify 2 of the judges off of the reconsideration, because I felt they were disrespecting the Ohio Supreme Court ruling. And there is case law that can justify removal of a judge for not following a higher court mandate. The disqualification got denied, and I knew I was running the risk of upsetting the judges, and I do practice in that court with other cases. It's, you always like to be on good terms with judges, and especially these are judges I've been on, at least friendly terms with before. So I knew I was running a risk of upsetting that dynamic, but at the same time.
So that's pending right now.
Well, the reconsideration got denied, so now what we're left with, we're within the period, a 45-day period, to appeal to the Ohio Supreme Court. But what we're also going to do is that we're going to take an action, another writ action against the 9th District of writ of prohibition, because we want the Ohio Supreme Court to declare that all those prior appeals are void. And because the 9th District, in deciding the case against Leroy, they gave credence, gave weight to the 1991 appeal. They called it the direct appeal, and it's like, no, it's not the direct appeal. That's void. That should not exist.
Today we have with us Leroy's uncle, James, yes, and his sister, and we're going to bring them on right now. It is my great pleasure to introduce Leroy's sister and his uncle. Welcome to the show.
Thank you.
You're known as Uncle James Williams, correct? Tell our audience a little bit about your nephew.
Well, he's been in prison now for about 30 years. I'm the one that go down to the courthouse and get all the papers and stuff that it take to get him out. And talk about harassment. I've been harassed quite a bit by the judges, telling me I ain't nothing but a clown, get out the office, don't go back to the office.
Really?
And then talked to quite a few lawyers about the case, but they were all scared to take the case. So I saw one friend of mine, he's a lawyer. I said, why are you scared to take the case? He said, because if we take the case, then we'll lose a lot of cases in Akron. Saying we can't afford to do that because they have families. So he said, if you want to get a lawyer, go out of town to get a lawyer. So I talked to a couple of lawyers out of town, but they same thing. They didn't want to take the case for some reason. He said, so I said, why don't you want to take the case? He said, well, I have my own reasons as to not want to take this case. One lawyer told me that he was in penitentiary because he was being kidnapped. Because from what he looked over the case and all the work he'd done, so he should have been out a long time ago. So they're holding him illegally. But he said, I don't want to get involved in it because there's too much politics in Akron. Right. And Akron is a city that where, things just don't work for the people that they call criminals. Yeah.
You're Leroy's sister?
Yes.
Yvette McIntyre, Ellen.
Correct.
Tell our audience what it's been like for you to see your brother locked up for 30 years.
It has been very painful for my family and his children.
How many kids does he have?
He has 5 kids altogether.
Wow. How old are they now?
They're in their 30s, yes. And he's a grandfather and about to be a great-grandfather. And, he's been incarcerated where he cannot attend his father's funeral, grandmother's funeral, uncle's funeral, the deaths of our loved ones.
A lot of people don't realize, and he's been wrongfully convicted, but a lot of people don't realize that other than spending 30 years in jail, a lot of things go on outside the jail, correct?
Correct.
That he cannot be involved with where your family needs him, right?
Exactly, sir.
You had mentioned to me before the show that how is his emotional situation right now?
It's very emotional because you're sitting up there and you're incarcerated and your freedom has been stolen away from you and you're missing out on activities, like I said before, with family, loved ones, and friends. Mm-hmm. And we miss the laughter with him. He's a joker. He's a kind-hearted person. And, we just want our family member back.
He's become quite a lawyer by himself, hasn't he?
Yes, he took up...
Learned the law well, hasn't he?
Yes, he learned the law very well, that they would like for him to take the bar exam and to actually work on one of their law firms.
James, what does justice mean to you?
Well, I don't see too much justice being taken care of. Justice means to me that everyone is created equal. Yeah. You can't give justice to some and then take it away from the others. Right. See, that's what our system is about. You know what I mean? I go out and do a crime, they're going to give me 30 years for it. And someone else come and do it, get them 2 or 3 years or give them probation. I've seen that quite a bit of times. So if you're going to apply the law, apply it equally. Apply it where everybody's created equally, not just the ones that just because you're white, you get it less. The penitentiaries, it's 90% black in the penitentiaries. Yeah. Now, as compared to white.
Right. Your lawyer, Steve, has done a fabulous job sticking with this case. Yes. What's your opinion of all of his efforts and everything?
The family is very pleased with what he has been doing and will continue to do to help us in our behalf of freeing my brother.
You're both on national TV. What do you want to say to the court? What do you want to say to the American people about your brothers first? I
would like to say that my brother is an innocent person that's been wrongly accused. I would like for my brother to come home and so he can be with the family, loved ones, and friends. To the public, more people have to get out and vote for these laws that they are making to make it better for all people, no matter what color you are. The system is set up to discriminate the poor more than it is the wealthy. And that's not justice.
You're on national TV too. What would you like to say, James, to the court system, to the judges, to America about your nephew?
The way I see it is we're in a bind because you got the police out here doing what they do. Then when they go to the prosecutors, they doing what they do. But when they go to the main person that has the authority to cross all this out that's being done wrong, the judges, they don't do it. You know, you're like one big family. You know, if you're a criminal, you're a criminal. And each one of them step up, as you step up, you don't get no satisfaction.
I want to thank both of you for being on the show. Let's hope he gets out of jail. Thank you.
Thank you.
When folks come into your office and they want you to represent them, how do you select clients?
I have to evaluate their case and have to ask them lots of questions about the facts and try to, you have to be very coldly objective with these things. And one thing I've learned is that you can't let your emotions get in the way. As much as you might feel for somebody, you have to have a very realistic view of whether this is going to succeed. And so I have to really interview them and get the facts and start thinking through how would the law apply to this. And I think what's frustrating about this case, when I look at Leroy's case and I see what the well-settled law says, and I'm thinking, hey, like we've got a really good argument to pursue, and because I'm not really getting paid for this. I mean, this is a project I kind of fell into, and it's something that I feel like this is just, he's been done wrong. Our justice system should not function this way. Should not act this way. It's got to do better. And so I'm looking at how what hit the facts of his case, the well settled law. And I'm thinking, okay, this is a pretty straightforward argument. That there's nothing complicated about this. This is a pretty straightforward path to justice, and we're just getting denied.
Yeah. I want to thank you for being on the show.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.